Copyright principle. Copyright protects only a work's expression, not the ideas it contains. Ideas may be freely taken and applied. This long-standing principle of copyright law is affirmed by TRIPS, Article 9.2. Copyright protection shall extend to expressions and not to ideas, procedures, methods of operation or mathematical concepts as such. And now, let's consider the case. Designers Guild Limited vs. Russell Williams, Textiles, Limited, 2000, 1 WLR 2416, UK, House of Lords. The plaintiff's employee created an original design for a dress fabric. The design consisted of vertical stripes, with flowers and leaves scattered between the stripes, all painted in an impressionistic style. The plaintiff successfully marketed the fabric. The defendant, having seen the plaintiff's fabric, then produced a very similar design for its fabric and claimed that it had copied merely the idea of the design, not its expression. The plaintiff successfully sued for copyright infringement.
This case was published in the article Designers Guild vs. Russell Williams, 2001, FSR 113 on the website of the University of Cambridge as follows.
The test for copyright infringement in the United Kingdom was crucially explored in this controversy that went up to the House of Lords in November 2000. Designers Guild complained that Russell Williams had infringed the copyright of its fabric design, iamCIAO, when they created what they thought was a similar design, Marguerite. At first instance, Lawrence Collins had found infringement, but on appeal the Court of Appeal had reversed. The House of Lords restored the initial finding that there was an infringement of copyright. In particular, the decision discussed the manner in which non-literal copying was to be assessed. Interestingly, it was held that the correct analysis was that of a comparison that takes into account the cumulative effect of the copied features. Here, we include the visual appendix attached to the expert evidence submitted by the plaintiff to demonstrate the similarities between the designs. For a discussion of the role of expertise in this and other cases, please read the article, Looking Right, The Art of Visual Literacy in British Copyright Litigation by José Balido in the journal Law, Culture and Humanities, 2011.
Lord Hoffman gave his opinion as below. The distinction between expression and ideas needs to be handled with care. What does it mean? It all depends on what you mean by ideas. Plainly, there can be no copyright in an idea which is merely in the head, which has not been expressed in copyrightable form, as a literary, dramatic, musical, or artistic work. But, the distinction between ideas and expression cannot mean anything so trivial as that. On the other hand, every element in the expression of an artistic work, unless it got there by accident or compulsion, is the expression of an idea on the part of the author. It represents her choice to paint stripes rather than polka dots, flowers rather than tadpoles, use one color and brush technique rather than another, and so on. The expression of these ideas is protected. The distinction between ideas and the expression of ideas supports two quite distinct propositions. The first is that a copyright work may express certain ideas which are not protected because they have no connection with the literary, dramatic, musical, or artistic nature of the work. It is on this ground that, for example, a literary work which describes a system or invention does not entitle the author to claim protection for his system or invention as such. The same is true of an inventive concept expressed in an artistic work. However striking or original it may be, others are, in the absence of patent protection, free to express it in works of their own. The other proposition is that certain ideas expressed by a copyright work may not be protected because, although they are ideas of a literary, dramatic, or artistic nature, they are not original or so commonplace as not to form a substantial part of the work. It is on this ground that the mere notion of combining stripes and flowers would not have amounted to a substantial part of the plaintiff's work. At that level of abstraction, the idea, though expressed in the design, would not have represented sufficient of the author's skill and labor as to attract copyright protection. Generally speaking, in cases of artistic copyright, the more abstract and simple the copied idea, the less likely it is to constitute a substantial part. Originality, in the sense of the contribution of the author's skill and labor, tends to lie in the detail with which the basic idea is presented. In this case, however, the elements which the judge found to have been copied went well beyond the banal, and I think that the judge was amply justified in deciding that they formed a substantial part of the originality of the work.